So as we get started, I'm going to ask everyone to just mute your phones or your computer, whichever that you're on, for this evening. And I think I know everyone that's on the call, but I'm Adrienne Lance Lucas, president of the National Alumni Association of Spelman for the Atlanta chapter. So welcome this evening. We are in part 4 of our 10-part series with Bank of America for our Women's Wealth Building Wednesdays. And we have had just amazing information shared since day one. And so I'm going to stop there and turn it over to Tiffany Eubanks Saunders, and she's going to introduce our guest speaker for this evening, Karen Salmon, who is a senior trust officer. Tiffany, why don't you take it from here?
Absolutely. Well, thank you, Adrienne, and thank you, ladies, for joining this evening. This is the busiest time of the year. It's my favorite time of the year, and even in the midst of a global pandemic health crisis at what seems to be its height at this point, I'm so glad that you ladies decided to join us this evening as we continued on this journey, as Adrienne mentioned, of creating a lot of knowledge and information by us, for us, because the reality is we as Black women have not been focused on in the past by the wealth management industry. And so a lot of the information that our peers and colleagues in the majority community have always had, we just have never had the benefit of having. And so it's such a pleasure for us at Bank of America to bring forth this information and share just what we believe is basic foundational information. Really the keys to beginning to identify where there's an opportunity to create generational wealth, and then giving you the components of information that you need in order to put one foot in front of the other and move down that path. And so as Adrienne mentioned, I am Tiffany Eubanks Saunders. I'm a market executive at Bank of America's private bank in Tennessee. I cover Tennessee and Kentucky. And I have been with the bank for a little over 27 years, worked in a lot of different areas, pretty much every one of our lines of business, and settled into the private bank wealth management space because, quite candidly, as I was working in other areas of the company, what I realized is that people of color were not focused on or targeted as it relates to having this type of information. So I've spent the last several years of my career and hope to spend the next couple of years of my career really focusing on creating education and awareness in our community, and specifically for Black women as we are leading the community that we come from. And so it brings me great pleasure to have this evening with me one of my colleagues, Karen Salmon, who is located, and she's joining us from California. She is one of only 2 Black female senior trust officers at Bank of America. And she is phenomenal at what she does. She is extremely experienced and caring in how she treats her clients. And I can't think of anyone better to bring to the discussion this evening around a topic that, quite candidly, has been a myth or a mystery in the Black community. And that is everything that you need to know about trust. It is one of the most foundational components of really beginning to create wealth and properly manage wealth to future generations. But quite candidly, it's one of those components or one of those areas of information that we just don't know a whole lot about. So Karen has a lot of information to share. We're gonna try to hit the highlights this evening and allow you all to take away some of the information. Adrienne can share the slides that Karen's gonna go through, and you can take those away. And then of course, we've got another estate planning session that we've got scheduled for early 2021, where we can pick up the conversation and move forward. And of course, as always, if you all have any questions for us coming out of this session, just shoot them over to Adrian and we're happy to answer them in the meantime. So without further ado, I'm going to turn it over to one of my partners in crime, Karen, and she'll walk us through all about the trust. What are they and how to use them? Thank you for joining us, Karen.
Thank you for having me, especially since this is a topic that is near and dear to my heart. I've been with the Bank of America this time for 5 years. And as Tiffany said, I'm out in California, so I missed the winter weather. However, I'm happy to join you and live vicariously through you. Since we are short on time, I'm going to hit the highlights about trusts and estate planning, and we can go in depth in the next one. If you want to go through the next couple of slides, please. One more, perfect. This is perfect, stop. Let's talk about what is estate planning, because trusts are a component of that. And the reason that we want to have estate planning is to have a trust to avoid probate. Probate is a means by which your state gets to determine through your will how you want your assets to go. And your assets, they're stuff. If you think of all the stuff that you have, those are assets. And if you just have a will, the state will say, okay, let's talk about it. They'll make it public. Everybody can go down and check and see, what did Tiffany own on the day she died? Oh my gosh, this is what she had? Suddenly we got all sorts of relatives. Remember Prince? That's, let's be real frank about it. And if you don't have a will, God forbid, the state has a wonderful plan, but it may not be wonderful for you and your family. So what a trust does is a trust says, okay, we're going to take all of our stuff and we're going to tell our people that we want to have knowledge of this, how we want it to go. Using my family as an example, I have 2 children and a niece that I consider mine. And let me tell you, that thing is being hidden until I die, because if I don't, they may kill me just to get it. No, I'm kidding. My family is awesome. But what I found out was when I introduced this to my parents, who were quite educated, father, retired professor from Howard, mom got her bachelor's degree in library science and psychology at Howard, they looked at me like I was insane. It's like, we don't have anything. And it's like, you do. You've got house, you've got this. People don't realize that what we have is, it's worthy of being protected. And a trust protects it, it keeps it private, and it also does something that a will doesn't do. God forbid we become incapacitated. And unfortunately, most of us will, because we're living longer. A trust allows for the orderly transition of somebody to come in and take care of you and your family when you're in a position where you can't do that. That will won't do that. That will simply starts at the day you take your last breath. And then, people are like, well, we can have a power of attorney. Well, the problem with the power of attorney is some banks and financial institutions don't really recognize them. And if they do, they may not be as broad as you need. So let's not even go there. Let's just do a plan in which we do a will. And that's, catch anything that we may have inadvertently forgotten. We have the trust. It's a revocable living trust, which means I still have complete control over my assets, but should something happen and I can't act, somebody is already in place to step in and act for me. And if I like that, but when I pass away, everybody will know who gets what. And it's amazing. And I'm sure you've had it in your family, how all of a sudden things change when the matriarch or the patriarch passes away. And unfortunately, in our community, we don't know that we could have saved some of this grief and anguish and publicity. And the other part is probate's expensive. It's statutory fees. People are like, oh, it costs too much money to make a trust. Yeah, it may cost a few $1,000s, but I can guarantee you probate's going to cost more. Because whereas in a trust, you don't have to go to court, so you don't have to lay out all of your assets. You have to do that for the tax man, but that's a different conversation. But in probate, they will say, oh, you have a house. Your house is worth $600,000. You may owe $300,000 on that house, but the probate fee is going to be based on that $600,000, not the net. So it's another reason. When I lost my parents, and unfortunately, I allowed their attorney to talk them into doing a testamentary trust. Because they said, oh, Maryland has a modified probate. It's not like that California probate. And people in California do trust. We don't do trust. That was the worst mistake I ever made in my life. Before we had my mother buried and shipped to Minnesota, I was getting letters about my parents' property. And I'm like, what the heck is going on? Duh. I'm so used to trust, I forget. Probate is very, very public. So it's nice to avoid that for your family because it comes at the absolute worst time. You know, you're grieving. You don't want to deal with that. Can you advance the slides, please? Probate, we talked about that. One more. Trust. Okay, this one is the one we're going to focus on because what a trust is, it's a legal entity that holds assets. Remember, stuff for the benefit of another individual or organization. And it's usually created to avoid probate, to protect the assets. That's for future generations or to reduce taxes. When we get into the estate planning part, we'll really zero in on the protect assets or reduce taxes side. Our biggest thing here is avoiding probate. And so what you do is the trust document tells you why you've created the trust, who you're going to benefit, who's going to manage the trust, and how long the trust will last. Most states, there are a few exceptions, and we won't talk about that. They have what's called a period of trust terms. You can't have a dynasty trust, one that will go on forever. But most states, it's usually such a long period. It's like 99 to 100 years. Honestly, I know my grandchildren. I hope I get to learn and know my great-grandchildren. But after that, I'm not going to know these people. So seriously, do I really need a dynasty trust? I'm not a multimillionaire. I'm not a billionaire. So the answer is no. I can go through 2-3 generations, and that term is good enough for my use. The important thing is starting the trust to begin with. And that's where a lot of people seem to run into a huge hurdle. We don't want to talk about the possibility that we're going to die. Well, I got news for you. We are. We don't want to necessarily get into, well, who's going to take care of the kids? Because I know when my husband and I, the happiest day of my life was when my youngest turned 18, because I had to compromise. So I had to name guardians that I was really happy that I survived the term. Let's just put it that way. But what the trust does is it sets up an orderly way for whoever the guardians may be to be able to take care of your children the way you want to. Trust gives you control. And it gives you control. My husband's like, I'm dead, I don't care. I'm like, I'm dead and I do care. I want control as long as I can have it. In case you can't tell, I have a type A personality. But I also know I want to be able to safeguard what little I do have for the future generations. And I want to be able to teach my children how to start and continue building, hopefully on what I did. I built on what my parents did. Now I want them to build on what I do. And that's going to be handled through a trust document. You can definitely you can make trusts at any point, but if you do it while you're alive, it's called inter vivos. And that just means you did it while you were alive. And then if you do it testamentary, it's after your death, which kind of defeats the purpose because, as I told you before, I ended up having to go through probate anyway. So better to do it now because you also get to control it a little more. The benefits. The big one for me is incapacity planning. And I say that because my parents made it to their 90s. What did my mom say? I ran into 90s and hit a wall. She had some capacity issues after that. And so if she had established the trust during her life, we would have known what her wishes were. Fortunately, I did have her complete the other part of the estate planning document, so we did know if she wanted to be kept alive or not. That's not in your trust, but it is in your estate plan. The asset protection, this only goes to your beneficiaries. You don't really get asset protection as the grantor. Since these are my assets, if I get sued, they are available to be taken out of my revocable trust. When I die and it stays in trust for my children and my grandchildren, if my son who likes to drive fast, if he gets in an accident and gets sued, this small pot of money is safe from his creditors because it's not his, it's for his benefit. And legally that's two different things. If I had given him the money outright, it's his. If it's in a trust for his benefit, that's asset protected. Tax mitigation, until we know what's going on with the tax that's coming up, I have no idea that I even want to touch this one. So we'll defer that one until 2021 or beyond. The other big thing is the privacy. I can't begin to stress how important privacy is, especially since if you've got a little something, they always seem to come out of the woodworks once they know that somebody's got something out there. So a trust alleviates that. The only people who will get noticed are the people who are named in that document. Next slide, please. How a trust is established. You work with an attorney or a paralegal in many cases, and they'll give you a set of questions. They'll figure out who you want to be the beneficiaries. If you can't act, who you want to be the trustees after you. The grantor are the person or people who actually create the trust. I have a separate property trust where I'm the grantor, and then I have a trust with my husband where we're both the grantors. You fund the trust. I'm in California, community property, or as my son has learned, what's mine is mine and what's his is mine. But for trust purposes, my separate property, i.e. the assets I got from my parents, that's in my separate property trust. In our joint trust, we have my husband's business, and then the rest of the assets that we brought together. Okay. His parents passed away. He has his own separate property. It's not in a trust, but that's a whole nother story. About the cobbler's kids that didn't have shoes, kind of the same situation. The principle of the trust is your assets or your stuff that you put in it. Your bank accounts, your home. You don't want to put your cars in there until after you pass away and they're not being driven. But all of the stuff you put in it is called your trust principle. The management. You as the grantor, you don't necessarily have to manage your trust. You can have Bank of America if you wanted to manage your trust. I have a lot of clients who are perfectly healthy, happy, they're living their lives, but they've resigned. They started out being the trustee, but they've retired, they're traveling the world, so they've resigned, and then Bank of America steps in. So we take care of the management, we pay the bills, anything they need done as the trust manager, trustee, that's what we do. And then we talked about the trust term. Some trusts end when the two spouses die. Other trusts go on to their children, grandchildren, great-grandchildren. And then as we talked about, some go on forever. like the Rockefellers, the Morgans, Chase, okay? This slide just talks about what happens if you become disabled. Your trustee steps in and becomes the manager. Your durable power of attorney can allow your agent to transfer assets in and out of the trust if that's what your power of attorney says. That's a more deep discussion that we'll do in estate settlement. And then at your death, your revocable trust, which means it can be changed. You can change it at any time, add to it, subtract from it, anything you want. But when both grantors die, it becomes irrevocable. No changes can be made. It is not a public document. It's not filed anywhere. It's not given to anybody who is not a party to the trust, meaning a grantor or a beneficiary or a trustee. And then it also cements how these assets are going to pass. Because I can't tell you how many times I've been in a room where, well, mom says I get this. Well, it's not in the trust, so mom may have said it, but she didn't write it down. And then, of course, it avoids the probate for any assets that are held in the trust, including real estate in other states, which is really important if you happen to have real estate in a state other than where you live. Because if you do, and you don't have it in your trust name, that would have to be probated in that state. Okay. The next slide. And this just tells you that you really have the ability to change it. But the cons are, it does cost you money to set it up. You still need a will. You still need advanced healthcare directives, because some people go, well, I have a trust, I don't need anything else. Well, that's a fallacy. You do need all the documents. And once you set it up, you do need to review it. I've had people bring me trusts that they set up in the 70s, and they're like, oh, well, you know, it's fine. And I'm like, so nothing's happened in your life since 1970 to 2020. And they're like, well, yeah, kids grown up, we got grandkids, we got great grandkids. And I'm like, uh-huh. And they're like, oh my God, you're right. So it is important to look at this. And here at the bank, part of my job is to help our clients by periodically reviewing. And then if there's anything that changes in the estate planning arena, bring it to their attention to make sure that their trust still is able to handle the new, improved, supposedly, things that happen. Okay, the next one. This, I'm not going to go over this slide, but this is a wonderful one for you to take a look at, because it'll show you what happens if you don't have any plan, if you just have a will, and then, of course, the ultimate. And it's not just because I'm a trust officer, but the benefits, the real benefits of having a living trust. And I really can't stress that too much. Next slide, please. Really quickly, I wanted to get into some duties of the executor. The executor is the person who is in charge of handling your wishes that are in your will. And if you have a well-drafted estate plan, the executor, which doesn't have to be one of the trustees, successor trustees, but if you have a really well-drafted estate plan, the executor really won't have much to do, because all of the assets should be in the trust. If they aren't, then this person would file the will. Well, they'll file the will anyway, just to put it on. But if there's no assets in the probate estate, it gets filed, it gets stamped, and we move on. They're responsible for that, locating assets, safeguarding assets, doing an inventory, but and paying off debts. That's only if you don't have a trust, okay? The executor also will file the final tax return, because, you know, Uncle Sam doesn't just go away because we stop breathing, unfortunately. So we definitely need that final tax return. And then if it is a will, any of the assets get distributed to the heirs or to a testamentary trust that was established. Next page, please. The duties of a trustee. When I saw this, I was laughing. This is the shortest slide I've ever seen on duties of a trustee. And I think that's because we don't want to scare you. But The trustee is responsible for reviewing the trust instrument. It's pretty much the same as the executor. Inventory, invest, and manage assets, filing tax returns, distributing income and principal pursuant to the terms of the trust, and the big one, maintaining records and providing information to the beneficiaries. That's a big one. That's where a lot of individual trustees slip and fall. You have to give information to beneficiaries. If they don't know what's going on, they make up all sorts of things in their head, and it could come back to haunt you. So it's, in some cases, it's the best thing to have is a trustee who is either a co as an individual and then a corporation, for the simple fact that as a corporation, we know what needs to be filed, when it needs to be filed, who needs to be noticed, and when they need to be noticed. If you do that, the decisions you make, and you make them in a methodical, logical way, you can stay safe. I'm not going to say you can stay out of court because anybody can sue you for any reason, but you have a legitimate process that you follow. Judges are usually not going to side with the beneficiary. And that's usually where the trouble comes in, is beneficiaries aren't given what they consider sufficient notice. Next page, please. I'm not gonna go through this because this is something that is personal to everybody, but some of the things that you should think about if you want to have an individual to be your executor or your trustee. It's an honor, but it's a lot of liability, and people don't realize that. It is a full-time job. I know, people look at me and go, well, why should I pay the fee? Believe me, it is the most reasonable fee you could ever expect, because if you don't have somebody who knows what they're doing, it could cost you a lot more in the long run. So that's one of the easiest objections to overcome. Now, this one is important because not everything can go into a trust. And people go, well, what do you mean? Anything that is owned, like a qualified plan, your IRAs, your 401ks, the trust can be the beneficiary, but the trust cannot own it. And the simple fact is that is something that is personal to you. So you want to make sure that anything that you can have a beneficiary designated on, you make sure that the beneficiary is designated. And it's something that you want to look at like you look at your trust document. You want to continue to look at that. Community property is what we have here in California, and that's, two people, you have to be married, and it doesn't avoid probate because guess what? Half of it belongs to somebody else. Now, there's a caveat to that. If you own it as community property with rights of survivorship, you have already designated, you've done a beneficiary designation, so you're fine. Tenants in common, it's usually 2 or more people in a non-community property state or that aren't married. And those tenants in common, like community property, can also be with rights of survivorship. You don't see that a lot because usually if it's a tenant in common, I want to decide what I'm going to do with my part of this asset. I may not want it to automatically go to the rest of the tenants. So that could be problematic. And then of course there's joint tenants with rights of survivorship. That to me is if you're going to own an asset and you don't necessarily think that you should have a trust, which you should, that would be the best way to hold assets, is in joint tenants with rights of survivorship, provided you like the other tenants, okay? And then of course, if it's sole ownership, it's going to go through probate unless you own it, like my husband. He owns his business as the trustee of our joint trust. And I have people who go, but it's a business. It's an LLC. It's a this, it's a that. And I said, that's wonderful, but your LLC needs to be owned by the trust. Your corporation needs to be owned by the trust. And a lot of business owners don't get that. So that's one of the things that I really focus on when I'm working with clients. And then the next page, disability considerations. A power of attorney is, it's a tool. I like it for certain things. A trust is a much better utilization of these powers that you're giving someone. The only thing that you cannot put in a trust is your healthcare power of attorney, or it's now called the Advanced Healthcare Directive. That is something that is separate, and it is extremely important. And one thing I want to say right here, right now, is if any of you have adult children, i.e. over the legal age of your state, make sure you get your kids to fill out a durable power of attorney and an advanced healthcare directive, because you as parents lose the ability to influence anything should, God forbid, something happens to them the minute they hit 18. And we don't think about that. But your kid goes away to college and something happens to him or her, you have to really go through a conservatorship in order to do medical or financial on their behalf. So that is my big push, is making sure anybody over the legal age has filled out those two forms. And then you're directed to physicians. Each one of us has the right to determine how we want to end our life. And believe me, it's tough when you're in that position. My dad and I were in the ER arguing over my mom. And as much as I wanted to agree with him, it wasn't what she wanted. And I really had to do what she wanted.
Yeah.
And then the designation of a guardian, we discussed that if you have minor children.
Hey, Karen.
Yes.
Real quick, I really want to put a pin in this one because many of the ladies who are on the call this evening are, part of that whole sandwich generation, right? Where you've got kids that are adult kids, or in some instances, still depending on you for some reason. And you've got, to your point, because of medical advances, we're living longer. And we've now got parents who are living to the point of where they need some help and assistance. And so I really want to make sure that everyone understands this is where we really get caught up. And this is where in the business that Karen and I are in, not having these things done, filled out, and considered at a time where you have all of your faculties about you, literally tears families apart. We see it every day, all day in our business. It becomes so destructive around the family core unit because people don't know and people make assumptions, and nobody is better to determine what happens to you when you are no longer in a position to care for yourself, or when you pass away and you transition. No one is better to determine what should happen with you, your assets, what you work so hard to build, or how you should be cared for. If you're in a situation where you're no longer able to care for yourself, you are the best person to make that decision. And I always say to my clients, it is the most selfless thing you can do. Amen. As a family member, to go ahead and make those decisions for yourself, get them well documented in these documents that Karen is talking about, and then share them with your family. Let them know, I've already figured this out, so you don't need to. Because I will tell you, we see this all the time, and it's heartbreaking to see families ripped apart and people not able to grieve the way that they should, because no one really knows what the intent of the individual was or what their wishes would have been. And so please, 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 if you don't take anything else away from this session tonight, you've got to get these documents in order.
Thank you. Thank you. Because this is the big one. This is the big one, which is why I left it for the end. And a lot of people go, well, I don't want to go to an attorney. every state has a website where you can download these forms and fill them out yourself. So they make it really easy, which is a blessing because it wasn't that way all the time. When I first started my career, you definitely had to go to an attorney to get a durable power or a healthcare directive. But now, like I said, each state has a website that you can go to and pull them down. And I believe me, I do it for my kids periodically because these are things that you should have updated every few years or so.
Right.
But it's not that difficult. And believe me, it saves a lot of frustration and grief. So, yeah. So get your parents to fill them out, get your adult kids to fill them out. It's okay to have more than you need because you never know when you're going to need them.
Right.
And I keep a picture of them on my iPad for each one of my kids and my husband.
Hey, Karen,
think
we
there
have
was
a question.
Yeah.
I was going to say, we have a question that came.
And it was, I couldn't quite get the whole thing.
Do we have to have a lawyer, hire a lawyer to hold these documents?
No. Honestly, I personally like to have an electronic copy, and then the original copy should be, in my opinion, with the client. There are a lot of attorneys that they have their will vault. Well, they'll hold your documents for you. Some of them even charge for it. My big thing is put it on make it a PDF, have it readily available. Because if you're out and you're buying something that's, a home or something, you want to have access to that pretty quick. But I have my original documents. They're in a cute little binder that's, sitting on my little bookshelf. But I have everything copied into a PDF that I have conveniently carry with me everywhere. Maybe that's just because I'm a trust officer, but it's a good practice.
Mm-hmm. And if you do have a, if you've got a medical power of attorney or someone who and here's the other thing I suggest is let people know that you want them to do this for you.
Oh yeah, don't surprise them. Yeah, surprise. Yeah, it's not a good thing.
That's usually not a good thing, but if you do, then it's often good to let them know or give them a copy as well. And that's a serious consideration also, because unfortunately, sometimes in the midst of grief, and it's hard for our loved ones to allow us to transition the way that we want to, or to have things, our assets and our wealth transition where we want it to transition. And oftentimes people don't necessarily, if you don't have these things in order, or you're not choosing the right people to play these roles, what sometimes happens is your wishes are not necessarily carried out. And so those are things that you just have to consider and really have an honest conversation with yourself. I'll tell you, I am actually, believe it or not, I'm actually the medical power of attorney for one of my best friends, because what she knows is that as much as I care for her, I'm going to do what she wants me to do. And she knows that her sister, her husband will not be able to allow her to transition the way that she wants to and take care of her affairs the way that she wants to, because they're not going to want to let her go. And so those are just things you just have to think about realistically. Who in your life do you trust to put into these certain positions, these key important positions, so that as you move on or if something happens to you, that you're able to transition you and your assets the way that you want to and the way that you see best fit. Because to Karen's point, it is a way to control what you think makes the most sense for your loved ones when you're not here to control them yourself. But you have to have the right documents and you have to have the right people named to implement those documents in order for that to be completed.
I have a question. I am a Bank of America customer, and I am the trustee of an irrevocable trust.
Okay.
That is, I guess, a sub trust of a trust my mother created that became irrevocable when she passed. So I'm handling the activities of that the trustee is responsible for myself. But I wasn't aware of the services that Bank of America provided. So do you also just, for customers provide some consultation services? And is that something that you have to go to a certain location? Not every branch would have such services, right?
Right. That's not something that we have in the branch location.
In the financial, yeah.
Then, yeah.
Yeah, it depends on the type of client. It depends on where you're a client of the bank. So Karen and I sit within the private bank, and all of our clients have access to those services because that's part of what we offer as part of our platform. In other instances, in what we call our consumer bank, or our financial centers that are typically the 5,500 branches or financial centers that you see all over the country, typically they are not providing consultation. We don't have trust specialists that are in those financial centers. We oftentimes, and I believe we'll check on this, but I think we've got tools online that you can reference
Okay.
as part of our financial education platform that you can self-service and review the information and ask questions. But we don't have people in our financial centers that have our trust specialists or have any level of experience around, trust matters. And oftentimes clients will go and seek the advice of attorneys in establishing those trusts, and then work with the bank to, put in place whomever's going to manage that for them. There are a whole litany of ways that you can get the trust established and then determine who is the best one to administer the trust and make sure you've got the right accounts tied to it. But that's not it's not a service that we offer in general in our financial centers.
Gotcha. Okay. And so I have a situation, and I'm wondering how other people handle this. My property that one of the properties of my mother's home is in the trust, but I need to refinance it. And so I'm told that I have to take it out of the trust to refinance it and then put it back in the trust. And I'm concerned that what if I get hit by a bus while it's out of the trust?
Yeah.
How do people deal with it?
Unfortunately, there's a lot of lenders that will not lend to an irrevocable trust. They will make you pull it out, refinance it, and then deed it back into the trust after it's been refinanced. I've been doing this for over 30 years, and I haven't figured out a workaround. The one hope I can give you is if it's in the trust and God forbid you get hit by a bus before it gets back in the trust, the successor trustee can always go and say, hey, this was always the intent. And you file a motion and get that put back into the trust. So it can get put back into the trust, but there's no easy way to do it if that happens. And believe me, it has happened where the house was taken out, refied, they forgot to put it back in the trust, and then somebody passed away.
Yeah.
And we just had to go to court and have that taken care of that way. It would be nice if everybody did the same thing, but we don't. So unfortunately, that's just the way it is. Yeah. Sorry about that.
Okay.
Well, ladies, I'm gonna keep my promise because I know that.
Still take a couple questions though, Tiffany,
Yeah.
if there still are some, because I actually have a question because as we talk about trust, I think, Karen, you mentioned several times that there's a fee, right? This is a fee for service proposition, and it comes in two ways, one establishing and also the maintenance. So can you talk a little bit about what that fee level or range is for each of those areas?
Okay.
And how we
Yeah,
should go
it's
about
broken.
thinking through, should we use an attorney or should you use the bank, et cetera? Can you give us some guidance on that?
Okay, well, okay, first of all, we're talking about two separate things. So I'll address the first one and then I'll get into the bank. The fee that an attorney charges, it's an estate planning fee.
Right.
Some attorneys have a flat fee for, a certain type of trust. Others attorneys charge hourly. Each state has different people within it and they charge different ways. In California, for a simple, quote unquote, simple trust, it can be anywhere from $2,500 to $5,000, depending on the attorney. But one thing I would say is if you were going to, I would go in and negotiate and say, hey, this is my situation. How many hours do you think it'll be? Can I get a flat rate as opposed to hourly? That would be what I would do. The attorney has the right to say yes or no, because I noticed in Maryland, they didn't have like a flat fee. It was hourly. So like I said, different attorneys do it different ways. The maintenance fee, and this is where I'm not quite sure. Some attorneys have what they call maintenance, where they charge you like $100 a year to hold your documents. To me, I'm really capable of holding my own documents and saving $100. To me, a maintenance fee should only come as if I make a change. When you go in and make a change to your trust, they're doing some more work. You're making an amendment or you're going to completely restate it. That would be an additional fee. But a maintenance fee to me, unless that maintenance fee comes with all the amendments and restatements that I can do, I wouldn't pay it. I would just say, give me my documents and move on. As far as the fee for a bank, that would be when we actually step in and act as your successor trustee. That's when we charge a fee. And to be perfectly honest with you, it is the most reasonable fee in the world because it's usually on top of an investment management fee. Because most of my trust clients start out on our investment management platform. That has a fee. And once we step in, we charge an additional 15 basis points. So that's 1/15 of 100. So it's a reasonable fee. I like to say I'm the most reasonable person in the world, and my husband disagrees, but that's another story. Okay, so that's the bank fee. Banks don't draft trust documents.
Right.
My job is to get everything teed up so that when you go to the attorney, when my clients go to the attorney is very clear on what they're looking for. Whether it's a new trust or we're amending or restating an existing trust. That's my job, is to hand my clients their wish list so that the attorney has something to work on. Did that answer your question?
It did. Thank you.
Yeah, and I'll just, just to kind of connect the dots here. So, Adrian, last month we talked about taxes. And we talked about, we had Tara join us, Tara Butler, a wealth strategist. And one of the things that you heard there is that the bank we don't do taxes per se for our clients. What we do, very similar to what Karen is saying here, we make sure that we advise around certain ways to manage your wealth and your investments to try to minimize your tax burden, but we're not going to be the ones to actually file for those taxes or manage that process for you. Very similar on the trust side, where we are not going to draft, even though many of our trust officers are attorneys, they're not acting in that capacity to draft trust documents for our clients, but they can make sure that our clients have thought through everything that needs to be thought through and had the conversation so that when they go to the attorney to draft the document, they know what it is that they want to have included in that trust and how they want it structured. And then we work with the attorneys for the clients to manage that process and that review over the lifetime that that trust might exist, and they're our clients.
Exactly.
Very good. Okay.
So it's 22 after.
Yes. Are there any other questions? We can take one last question before we go on to the Christmas Carol concert.
Is there a net worth, personal net worth that we should be concerned about to say, okay, with immediacy, we need to do these things? I know about the basic documents, but we're talking about a $2,500 to $5,000 investment for this estate planning trust. At what point do you what net worth is that an imperative, I guess, is what I'm trying to say.
I'm not going to say it's a net worth. I'm going to say it's an asset. If you own a home,
Yeah.
to me, a trust is a good idea if you own a home. Because I know a lot of people go, well, I'll just put so-and-so on my deed. So if I die, then the house goes to them. Well, okay, that may not be the way your plan goes. So, and not to mention that if you do that, you're still going to end up paying that $2,000 to $5,000 in probate.
Right. That's right.
It's not a net worth, and that's where, in my opinion, the biggest fallacy is. It's, well, I don't have you have a house.
Okay.
My son needs a trust. We've just talked about it because we helped him get his condo last year. And I'm like, dude, you got to get your trust now. And he's like, but you have an asset. I don't want to go through probate ever again for anybody in my family. Not happening. Everybody needs a trust. That's my thought. And it's not just because I'm a trust officer, but it is because I don't want everybody knowing what I've got. That's just me. And I don't want to put somebody on my house just to avoid that, because they're still going to end up paying a ton of money when it could have been avoided. And your attorneys may not be that expensive. And to be honest with you, there's some online, if you have a really simple situation, there's some online vendors that do a halfway decent job. I mean, my clients that use that, they have a net worth in excess of $5 million. And they bring me a document that's off the internet. And in some cases, it's perfectly fine, believe it or not. But in other cases, it's not. Is there an age? Okay, there was another question that came through about an age. I'm sorry, these eyes are old.
Yeah, the question says, is there an age by which a person should have a trust, or is it based on assets?
In my opinion, it's based on assets, but you do need to be an adult to create a trust, because it is a legal document. So the minimum is whatever the legal age is in your state. But to me, it's more about what stuff do you have? What assets do you have? It's all based on assets.
That's right. And the way, to me, the simple way to think about why have a trust, regardless of what your wealth level is the fact that, one, as Karen mentioned, there will be costs. There are costs that you can avoid down the road by making the investment sooner around protecting your assets, because that's what you're doing. You're pretty much creating a bulletproof shell, which is why Karen said every asset you have that is eligible to go into the trust should go into the trust. I know we've got a lot of business owners who are on this call and who are part of the organization. Notice she talked about the fact that her husband's business is owned by the trust so that it is protected from fees and cost expenses, as well as liability. That's the other thing down the road. And the other thing I'd say is a lot of these other instruments that are used, we always hear about wills being contested, around challenges to deeds. All that stuff is a lot easier to happen or to occur when you don't have it protected within that trust. I mean, the law really does favor trust structures and the fact that they're valid, and it's just more difficult for people to change things that you want to have happen when you're no longer here, when they're in a trust versus some of these other types of instruments.
Yes, exactly. And you can't give instructions to your power of attorney holder. You're simply giving them free, unfettered access to your assets, but they don't have a marching order of what should be done with them. That's another thing to remember.
Yeah. So Adrian,
So
it's
ladies,
3 minutes before half past the hour.
Okay, yep.
Yes. So we are going to wrap this up. There was one additional question, if you can answer it quickly, and that is, how do we go about interviewing and selecting an estate lawyer?
Interview. Pick somebody you feel comfortable with, because you will be discussing things that are very personal to you. So I always say at least 3, and just talk to them. Find out. I have never met an attorney that is not willing to chat with you for free in order to gain some business. So go with your heart and go with what makes you feel comfortable.
Yeah.
So Tiffany and Karen, again, an outstanding session. Thank you so
Thank
much.
for having us.
Bank of
Thank you for
America
having us.
Yes.
And we will see you again, Tiffany,
Yes.
in January, where we will talk about estate
That's
planning.
right.
We'll
We're going
go
to pick
a
right up
level
where we
deeper.
left off. Continue the conversation. Exactly.
Definitely. Thank you guys, and everybody have a marvelous holiday season.
Yes.
And
Have
Happy
a
New
wonderful
Year.
holiday. Stay healthy, stay
Healthy.
well, and be safe.
Yeah.
And
And if you
Merry
have any
Christmas
questions,
concert.
yes,
Merry
definitely.
Christmas.
Thank you guys.
Thank you.
Bye-bye.